Hello, this is Mr. George, and this is Web Lecture 5.2. This is the second part of the conflict and resolution lesson. Now today, as I discussed before, we're going to talk about one of the practical ways that we resolve conflict in the United States, and that is through the system of the courts. So let's talk a little bit about that. So the people involved in a typical court situation are the prosecutor, and the prosecutor is the person that's responsible for presenting the case. This is the person whose burden of proof, who has the burden of proof to make sure that they prove that the person that is accused has committed the crime. So it is this person's responsibility to make sure that they have enough evidence to prove the case. And that case is trying to be proved against the defendant. Now, the defendant is the individual or maybe the group being sued in a civil case or charged with a crime in a criminal case. And the defendant technically has to say nothing unless, of course, the prosecution can bring up evidence that they have committed a crime or they are responsible for something that they are being sued for. So those are the two main people that are involved in the case. Now, if you are involved in a civil case, and you are bringing suit against somebody, that is not the prosecutor, but in fact, that is the plaintiff. And this is the person that initiates the lawsuit. So if you are suing somebody for divorce, the person that is doing the suing or bringing the case against another person, that is the plaintiff. Or if you and your neighbor have a dispute about your property line, and you are the one that believes that your neighbor has, let's say, built a fence on your property, and you sue that neighbor, then you are the plaintiff. So those are the people that are trying to prove that the other person has done something wrong in a civil case, or the prosecutor, the person that is trying to prove that the defendant has committed a crime. Now there are two different types of cases, as I mentioned. There are civil cases, and these are conflict cases. This is not a crime, but this is when you feel that you have been wronged, or your rights have been violated, or there is a complaint against one party or another. And this is where you begin a lawsuit. And so if somebody is being sued, means that they have had a lawsuit brought against them. And in that case, it is a civil case. The other type of case is a criminal case. And this is when you are involved in a case where you have broken the law, or a law has been broken, where there is some sort of enforcement of the laws. And the prosecution or the prosecutor is paid for and is a member of the government, because the government, that's whose laws you're breaking, they're ultimately responsible for charging you with the crime and then proving that you committed the crime if they want to punish you. Now, there are three different ways to be charged. There is an indictment. An indictment is voted on by a grand jury, and a grand jury typically is larger than your regular trial jury. It's about 25 people in a grand jury, and they simply weigh the evidence to see if they think there's enough evidence to bring a case against you, and if so, then they will indict you. There's also through the filing of information by the prosecuting attorney. So this is information that's brought to a judge, and if the judge is certain that there is a strong case against the defendant, then they will skip the grand jury and they will move forward with the case. And third, through a citation by a police officer. So if a police officer is physically there when the crime occurs, that is enough evidence to bring a case against an individual. Now there are different types of crimes. There's a felony, and a felony is a very serious crime. This is rape, murder, armed robbery, anything that is of that type of ilk, a serious crime, and this usually results in some sort of extended prison sentence if you are convicted of a felony. And as we talked about before, remember that felons in North Carolina cannot vote because they have been that right of theirs has been taken away because they've taken away the rights of somebody else committing their felony. The other type is a misdemeanor. This is usually a minor offense: theft, vandalism, unlawful camping, fishing without a license. These are all felonies. Now this results typically in a fine, sometimes probation, depending on the severity of the misdemeanor. And now A misdemeanor is something that even if you do get, that's not going to keep you from getting a job or keep you from gainful employment or admission to college or anything like that. Misdemeanors, while still crimes, are not of the serious variety. Now, when you're going to trial, there are multiple steps that come before the trial. The first of those is the investigation. This determines if there is, if someone's going to be arrested and charged with a crime, because they have to investigate, find out whether there's evidence. This may merit a warrant where they talk to a judge, the judge agrees that there is enough information to issue a warrant, and then they can find information. Then there is the arrest, and that's when an individual is informed of his or her Miranda rights. It's actually, as I stated before, you don't get Mirandized until you're actually charged with a crime. So the law enforcement officials have 48 hours to hold you without actually charging you with a crime. So that's the next step. Then you have your preliminary hearing if you are charged with a crime, and this is where you appear before a judge and they hear whether you are your plea, whether you're guilty or not guilty, and that's when bail is set. In misdemeanor cases, you will make a plea of guilty or not guilty, and the judge will set a court date, but this will not be a full-on jury trial, just a trial to determine your punishment. In felony cases, however, they usually use a grand jury to determine if they have enough evidence to move on with the case. There is no plea, and then a trial date is set at this time.